A late night ordinance by the Modi government has reversed a Supreme Court verdict that gave the Delhi government, led by Arvind Kejriwal, administrative powers, especially over the postings and transfers of bureaucrats. I'm Barkha Dutt, here with the Mojo story. In moments from now, we'll be talking to senior advocate and jurist Abhishek Singhvi, who won that case for the Delhi government and the Aam Aadmi Party. Intriguingly, the centre, while promulgating the ordinance, of course, issued through the office of the president, has also petitioned the Supreme Court asking for a review of the verdict delivered by a constitutional bench led by Chief Justice of India, Justice Chandrachud. It is important that this verdict was unanimous, but the centre supporters are quoting one line from the verdict whereby they argued that the Chief Justice himself suggested that Parliament was free to enact a law if it so wished. Is that really the case, or is this another centre versus judiciary battle apart from a Modi versus Arvind Kejriwal battle? There's a lot to unpack here. Abhishek Singhvi has gone on Twitter to say that this is a knock for federalism and for the federal spirit of the constitution. Let's go across to him now as we look at the big developments in this huge political story whereby the centre has both issued an ordinance, moved an ordinance, promulgated through the office of the president, and petitioned the Supreme Court to review its own verdict. Abhishek Singhvi, pleasure as always. Let me start by getting your first comments. You have said, of course, on Twitter that you think that this is a knock for federalism. But, you know, you've heard the arguments that in favor of what the centre has done. And now the centre has also petitioned the Supreme Court before, presumably, you've asked for a review. Your comments.
Okay, I'll answer all your questions, Barkha, but just step back for a minute. Of course, I made the preliminary point that this is the stupendously weird act of a poor, graceless loser. Before the ink is dry, you attempt to change the rules of the game by an ordinance. But just step back and ask yourself the question. You all agree that an ordinance or even an act, if it ever becomes an act, cannot change the constitutional principle, correct? An act cannot change, only a constitutional amendment can change constitutional principles. This bizarre act seeks to change constitutional principles. Now, all that the CJI said is to quote the Constitution, which gives Parliament the power to enact laws. For even Delhi, even for list 2, even areas where Delhi can enact law, Parliament can enact law. Nowhere is it said or can be ever said that the basic architecture, intent and rationale for the creation of Delhi's constitutional status can be nullified by an act of Parliament or ordinance. Just consider. Why did you create Delhi at all? You have to step back. Why did you give Delhi a special constitutional status with 239A? Why did you give it autonomy? Why did you say that barring 3 areas, there shall be no powers? It was because parliamentary democracy, federalism, and decentralization, all larger constitutional principles, not statutory principles. Federalism has in fact been held to be part of the basic structure, animated that underpinning. Number 2, that underpinning of constitutional principle has other constitutional principles. The civil service will always be answerable to the political executive, is another basic constitutional principle. Have you ever heard that you are administering a territory, I am the civil service, and I answer to X, but you are supposed to administer it? It's never done. That's why it's answerable. Number 3, this judgment 2 weeks ago gives the civil service entire power in part 14 of the Constitution, another constitutional principle, which has, as you know, 309, removal, suspension, punishment, all of that civil service power to the NCT government. So there are principles of autonomy, federalism, the very rationale for creating Delhi. You might as well have created Delhi as a national territory. You had no obligation to create Delhi as almost a separate state. Delhi is certainly not a union territory. It's a union territory plus. It is just short of a state because it has -3 powers. Now, a statute cannot negate that fundamental spirit of the entire 239AA. You have to repeal 239AA. And what you are now saying is that the sentence of the Constitution, which 239AA says that you can pass laws, So the Chief Justice has said nothing new in that line. He has only quoted the Constitution. Parliament can pass laws for the NCT. But that does not mean that you can completely change the constitutional underpinning of the system
Hang
and
on, I need to clarify that. Let's first bring up on our screen that particular paragraph that is being quoted all over the social media by supporters of the center. And you can see it on your screen, whereby they say that the Chief Justice himself said, however, if Parliament enacts a law granting executive power on any subject which is within the domain of the NCTD, the executive power of the Lieutenant Governor shall be modified to the extent, and so it goes on. Now, talk about this. Are you saying that this is not in reference to the basic principle of the Constitution, which is that the bureaucracy cannot be above the elected government?
all the principles which can be done. Let's take the maximum which can be done by an act. That is the limitation of an act of parliament. I'm assuming the ordinance to be an act at the moment. So assume that an act of parliament can do everything which an act can do. It is common ground that an act cannot affect any constitutional principle. It is common ground that an act cannot decimate, dilute, or undermine any constitutional underpinning. Now, what are the constitutional principles? One, federalism, decentralization, answerability of the civil service to the political executive,
Yeah.
autonomy in Delhi. If there is no such principle, then 239, can this act, now the para you read, can this
Yeah.
act say, we hereby dilute, decimate, or overrule 239A itself? That's also legislature saying so. It can't, because 239A is in the Constitution. Now, equally, if you can't touch 239AA, you cannot touch the entire constitutional architecture of 239AA, which must have a large measure of autonomy in Delhi. Otherwise, you might as well make Delhi a national territory of the center. And let me tell you, I have very grave doubts whether Parliament will at all pass it. What they've done is Barkha only to buy time. And that is why they're living on borrowed time. I have no doubt that, and one more thing, Barkha,
Yeah.
a judgment you cannot pass a law saying judgment is nullified. The judgment's basis can be removed, and then the judgment will not apply. You cannot remove the basis of this judgment and indeed the 2018 judgment, because large parts of that basis are based on constitutional principle, not on statutory principle. So you need a constitutional amendment. And if you have the guts, please pass a 2/3 constitutional amendment.
You're saying that the Chief Justice's comment does not cover the basic structure of the Constitution, and the
Or
basic
of the,
structure of the Constitution is underpins federalism and underpins the fact that the bureaucracy must report to the elected government.
also, it does not change, you're right what you said, but also it does not affect the basic architecture of 239AA itself.
Explain for our
239
viewers, explain to people who are not lawyers, what is 239 AA?
239AA was created. There's a whole part in the Constitution which has many sections, 239A, AA, etc., etc. I won't go into legalese.
Yeah.
Now, the debate there was that there were union territories like Puducherry. There were other union territories, Daman, Diu, etc. One part of these constitutional provisions kept them as union territories, which meant that they were administered directly by the central government. Are you with me?
Yes, I am.
The
I
central
am.
government was the government for that state. So when you had Kiran Bedi running Puducherry, it was the central government running Puducherry. When you had somebody else running Daman Diu, you had that person, the central government's man, running it, like an LG. You then created 239AA, which is a separate architecture for Delhi. It is unique in being the only non-state territory which is equally not a union territory. Delhi is not a union territory. It was given a unique constitutional status by 239AA. Now, before you reach the basic structure of the Constitution, you have to reckon with the basic structure and architecture of 239AA itself. 239AA architecture is, this shall be a special status, this shall not be a union territory merely. It is not a state, but it is not a state only to the extent of 3 areas. And it is underpinned, this reason we are giving you 239AA is federalism, autonomy, answerability to the political executive, administration by the political executive, not by a central government, not by the LG, the principle of parliamentary democracy itself, federalism, decentralization, parliamentary democracy. So what? Now, just tell you one thing. What is parliamentary? Do you have elections in Puducherry? You will have elections in Puducherry where the electorate does not elect in the same way as the 70 seats electorate elects in Delhi. There is a different architecture there. And by an act of parliament or an ordinance, you cannot simply, repeal or, nullify 239A. Also, you cannot repeal and nullify the larger concepts you mentioned, federalism, etc., which is part of the basic structure of the constitution.
What if Parliament were to move a constitutional amendment to actually change the powers by which Delhi is organized?
Actually, that
not
is
the
the
powers,
correct.
but the details. Yeah,
Absolutely
Parliament can
right.
do that, right?
You are absolutely right. Actually, that is the only correct way to do it. I'm not saying they should do it. I'm not saying they will do it. But that is absolutely 100% bang on the point. You should do it. That is the only way you can do. Now, what you can do in your methodology, Barkha, just now which you mentioned,
Yeah.
you can repeal 239AA itself. You can supplant it with a new 239AA. You can delete parts of 239AA. You can say that not 3 powers, land, public order, etc., but 20 powers will be with the central government. But you don't do it. Why don't you do it? Because you are paying lip service to parliamentary democracy. I'll give you a striking example of lip service, which will make you laugh. You are scared of the electorate because you know that what you are doing is an insult to the people of Delhi. The Nagrik of Delhi, the Aam Aadmi of Delhi, needs the power in his own hands to elect. Now, having given that, you don't have the guts to say that. But what you do is, you say, yes, you have a chief minister. So in this ordinance, you create a council with the chief minister heading it in a minority in his own council of which he is the chairman. The civil service is answerable not to the chief minister's executive, but to 2 other civil servants. In your own council, you are the chair, you are in a minority. Even the quorum doesn't require Barkha Dutt to be there. The other 2 can sit and have it. And thereafter, there is a super CM in that same provision called the LG. Now, this is what is known as pulling the wool over the eyes of the people. Why did they don't need to have a CM in this council? For the civil service, what's the need of a CM? They do it because they want to keep a fig leaf of parliamentary democracy, of rather the legislative assembly democracy. And therefore, they are scared. That is the answer to your question. That is why they don't have the guts to move a constitutional amendment. Certainly, a constitutional amendment with a special amending power would be at least a legally valid way to do it.
But suppose they were to go down that route. Currently, they have petitioned the Supreme Court and they've done it quicker than you. What do you make of that?
No. That's a non-issue.
Why?
2 answers. Why should I be petitioning the Supreme Court for review? Supreme Court judgment is in my favor, madam. 110%.
I know, but
So I no question of
the ordinance. No, I meant
no.
for a stay of the ordinance. They have
No.
moved the court for a review before you have
No.
moved the court for a stay of the ordinance.
No. Let's not get mixed up, Barkha, here. They have filed a review petition against the judgment they have lost. They have nothing to do with the review. The review petition and nothing to do with the ordinance. Forget the ordinance and review are 2 different things. Okay. They have, by a unanimous thumping judgment, no majority, no dissent, they have lost. That's why I say the graceless, poor, bad loser with sour grapes. They have moved a review to rectify that judgment. That review, as all reviews, has a normal statistical dismissal rate of 99.99%. That is basket 1. That review has 30 days to be decided. I mean, not decided 30 days, they have long time to be decided, the same. It is done by circulation. The judges don't have to hear you to decide to dismiss your review. There is no question of my filing a review because I have won the judgment. Separately, on the last day of the Supreme Court, when the Supreme Court has gone into recess, in the night on Friday, they passed an ordinance. An ordinance is a fresh cause of action which pretends to remove the underpinning of this judgment, which they have filed a review about. The underpinning of the judgment can't be removed because it is constitutional underpinnings, apart from statutory. They've tried to remove their underpinning by statutory means, even though it's constitutional. That's all.
What are your options now?
Oh, it will be challenged. I have no doubt that it will be struck down. Obviously, I'm never presumptuous about court. I'm speaking as a lawyer because it's a strong case. I have very strong hopes that it will be stayed. And I am reasonably certain that Parliament will not allow a ordinance to become law itself. Leave aside your larger question whether they can pass a constitutional amendment. A constitutional amendment requires 2/3. But I have a very serious doubt whether Parliament will allow this kind of invasion of federalism in especially the upper house.
You call it an invasion of federalism, but the numbers are with the government, right? I know a constitutional amendment, needs to be ratified by the states and so on. It's complicated, but at the moment, in the immediate, about the ordinance, are you confident the Supreme Court will stay it? And do you, given that this ordinance has come days after the law ministry was intriguingly purged of both Kiren Riijju and his deputy, do you see this as a confrontation which is political between Modi government and AAP, or do you see this as a legal confrontation between the center and the judiciary? Which one do you see it as?
First and foremost, the first one, to a large extent, the second one also.
Explain.
Both.
Explain.
First one, it's without doubt clear that there is some deep-seated internal heartburn where two constitutional entities, the central and the state NCT government, just can't get along. And I can tell you, and you can obviously discount the fact that I'm a counsel for one, that the provocation is 99.9% from the center. You could have let things rest. Number two, you tried to delay this hearing, which we won. We know for the last 3 years to 4 years, benches have been made, times have been sought, adjournments have been sought. Number three, you lost. You have to take winning and losing in a constitutional sense. You could have let things lie. Number four, you have now also therefore gone for a direct confrontation. Before the ink is dry on your judgment, you're telling the court that we are removing the basis, by the way, you told us to do. On the contrary,
they keep coming back to what the Chief Justice said in his verdict.
The Chief Justice doesn't have to say it. The Chief Justice doesn't have to say it. The Constitution says that if Parliament passes a law, that's the beauty. 239A says it. If Parliament passes a law, that subject shall govern even the state list. But Parliament doesn't say, the Constitution doesn't say.
How did you interpret that line by Justice Chandrachud? I want to bring it up on the screen again. When you read the verdict, about how Parliament is free to enact the law, how did you interpret it?
There is no need for interpretation. Barkha 239AA bracket 7 itself says so. The point is, when this architecture was created, Parliament was given the power to pass laws on some subjects. But Parliament was not given the power to pass laws in a manner, and that's the larger issue which will be debated when we challenge it, in a manner which will render 239AA OTOs, which will take away the spirit, will leave a shell of 239AA. Let me tell you an example. Tomorrow, Parliament, according to the para you're reading, can pass a law, say, we take away 29 out of 30 subjects of the list by passing a law. I pass one law on sewerage, one on your municipality, one on services, one on sneezing, one on rising and sitting, anything. So you can pass a law. Forget this paragraph. The Constitution says so. That's where the higher principle kicks in. That when you pass such a law, thereby decimating the entire functioning of the NCT, which was supposed to be limited to 3 areas only, then you are doing violence to 2 basic structures. One basic architecture, I won't call it basic structure, of 239AA itself. And then to the larger basic structure of the Constitution of India. And what are those principles? I've given you 4 of them. There are many more. Parliamentary democracy, the will of the people. Did the people want to elect you so that the services will be subordinate to you or will be governed by somebody else? Federalism, self-governance, autonomy. These are not principles which an ordinance can change.
Here's my question. If you basically saying that if the government really wants to go the legally correct, appropriate route, then it would be moving a constitutional amendment in Parliament that actually changes the very architecture of Delhi as a unique, almost state.
Exactly. They never do that. They neither have the guts to do it, nor the will to do it, but more importantly, they don't have the numbers for it. And they will therefore do this tinkering through statutes. This is actually not a statute even now. We still have to wait whether Parliament will pass it after 2 months in the monsoon session. I have my grave doubts. Can you try and nullify a judgment with an ordinance before the ink is dry? I mean, there is something beyond just constitutional text. There is something
Wh-
called constitutional morality. There is something called constitutional spirit. There is something called good governance. There is something called mutual reciprocal balance and respect. You're throwing all this into the dustbin and you're saying, technically, I am right because there is this provision in 239 What you are reading in that paragraph is nothing
Yeah.
but a paraphrasing of a constitutional provision. That constitutional provision gives me a power to take away 90% of your house, but say that Barkha Dutt is the master of your house. It's exactly that. I can pass a law as parliamentary law saying every room, every veranda, every bathroom is in my control, but you are still the master or mistress of the house.
Yeah, got it. But tell me this. Mr. Rijiju's exit was seen by many to be a sign of the government waving a truce flag at the judiciary. Very soon after, we had two new judges sworn in. Things looked like they were going to be smoother, and then this happens. How do you join the dots between all of these varied
I am
developments?
not connecting. I'm not now. I'm answering your question because I normally very
Yeah.
candid, but I'm not connecting the subject of your talk today with me with this point. I don't think I can
Okay.
find, unless I can find, but I can certainly say this. Whatever be the reasons, and there's going to be a mystery till your sources or my sources tell me the real reason.
Yeah.
Uh, Mr. Riijju, who clearly was shooting off his, shooting from the hip and had the foot in the mouth disease for many months,
Mm.
who do not have, and in this government, no one does have the guts to speak, not without only the support of the top people, but with the actual approbation, endorsement, and promotion of those people. So I think he has just become some kind of a fall guy, some kind of a scapegoat. I do not believe that in this government there is anybody who can say basic structures should be repealed. Somebody who can say I should be sitting in the collegium. These are both sentences he said, by the way, without actually being told to do so. So what has happened is he's taken the fall, he's taken the rap for somebody else's decision making. Today it may not suit them, it suited them for 3 to 4 months. Now what that reason is will still have to be found out, and I can discuss that with you in private when I find out.
Okay, give me 2 more minutes. I have two more questions, and the first is, be fair. As a Congress parliamentarian who has intriguingly, in your avatar as one of India's best lawyers, defended the Aam Aadmi Party, you will also remember that the UPA is not new to ordinances. Every government has sometimes disagreed with the court and moved an ordinance. In your
No, no,
case,
no,
it was famously the Rahul, the ordinance that Rahul Gandhi eventually objected to that has landed him his
no,
conviction.
no, no, no,
So
no.
an
That's a very
ordinance by definition, 1 minute, let me finish my question. An ordinance by definition doesn't mean you're taking on the judiciary, or does it? You've done it
Barkha,
too in
that's
your
a,
time.
Barkha,
Yeah.
that's a totally inapposite analogy. I have
Okay.
never in your last 20 minutes, even for a minute, suggested that per se the ordinance route is bad. I'm not saying
Okay.
it now, I've not said it. That's
Okay.
not the issue at all. The
Okay.
real issue, if you ask your question differently and rephrase it, is that there have been governments in Delhi for last 30, 40 years. There have been BJP governments in the center with a BJP government in Delhi. There have been a
Yeah.
Congress government in the center with a BJP government here. There has been a Congress government in both places, all forms and combinations. Have you ever found the pettiness? And that's my point. It doesn't matter whether I'm a congressman or a BJPite or a AP. My point is, in all formulations, A and B or A and A, you have never found the kind of pettiness, small heartedness, vendetta, nitpicking, obstinacy, laggardness, delay, obstruction, which you are finding by this central government, with this NCT government. Tomorrow you can be here. Day after I can be here. The party to which you belong may not be there in the center. The party to which I belong may not be in the center. Delhiites can't suffer because of that principle. That's the whole purpose, meaning of constitutional reciprocity and reasonableness and good sense and statesmanship. These are only adjectives to be thrown to the dustbin.
Last question. Do you believe, given that this was a constitutional bench, it was a unanimous verdict, do you believe that this is something that the bench will see as an affront?
No, no, no. Judges are trained people. They don't see things as affront. There is a methodology that you can change. You can render a judgment inapplicable by removing its basis. You cannot
Yes.
pass a law saying that a case called A versus B is hereby reversed. You can't pass that law. But you can pass a law saying, I am doing by this law X, Y, Z. And X, Y, Z being the underpinning of that judgment can render that judgment ineffective. But when the underpinning of a judgment is 50, 70, 80% constitutional principle, then you cannot do it, Barkha Dutt, except by a constitutional amendment. You cannot do it by an ordinance, even if I assume with you for the time being that the ordinance is an act. And I have not for a minute said that per se the use of ordinance is illegal.
Yeah,
I am saying which government
Vajpayee in the Congress history.
I am saying what I am saying is which government, be it Sheila Dikshit to Vajpayee, be it Sushma Swaraj to Vajpayee, has ever acted qua Delhi in 50% of the manner, in 30% of the manner which this government is acting. It's actually an insult to the very people of Delhi. That's all there is. And that's why they will not bring a constitutional amendment.
What finally are now the legal steps for the resolution of this issue, whichever way it resolves itself?
No, it's nothing but the legal route. That's why I said you've done nothing but bought time. Even the framers of this know it's going to be struck down, I can say this. But that takes time. As you know, the process becomes the punishment. So you are living on borrowed time. You're living on borrowed time, but someday I think this will happen.
What will you do as a counsel for the Delhi government? What do you intend to do?
Well, if they ask me, I'll appear. I'll appear and fight it.
What would you advise? What would you advise to be done?
Whatever I've told you for the last 20 minutes is going to be part of the whole petition.
No, I understand, but I'm saying, will you be moving quickly to ask to stay on?
Those are strategies. Those are strategies which should not be disclosed on camera. But you can rest assured that there'll be a challenge. The challenge has every chance of success. There are 2 degrees of success. One is a quashing, which I do not think is going to take too much time. The second is an interim relief, which will be seen as and when we file it.
All right, Abhishek Singhvi, I think you've got a busy week ahead. You always have a busy week ahead, but maybe even busier than usual. Always a pleasure. Learn so much. I feel like I'm in law school sometimes interviewing you and learn so much. Thank you so much. Take care. Thank you.
We started Mojo right here in this basement. Just 4 people. 4. And now we're about to hit our first 1 million subscribers. So this is to say thank you to all of you for your support, for your respect, and for your encouragement. We've always gone to where the story is. During the pandemic, when television's big anchors were hunkered down in their studios or at their homes, we hit the road. We traveled from Delhi to Kerala, covering 30,000 kilometers in a small car, reporting from inside ICUs and inside slum tenements. Whether it's flash floods or war zones, we've always put our boots on the ground. In fact, we're just back from Punjab, tailing the Khalistani fugitive Amritpal Singh. And through all of this, we have always put you, the people, first. In an age of partisan polarized media where most journalists are either chamcha ya morcha, we believe the story is sacred and the truth of the story is what matters. And now as we get ready for the next step, we need your help. Become a Mojo member and get first access to all our big interviews. Get a chance to ask our newsmakers questions. Get a chance to write and report for us for both our website and our channels. And also, interact with me and my colleagues directly through AMA sessions. Literally, ask me anything. Click on the join now right next to the subscribe button, and yes, also subscribe if you haven't yet, and become a Mojo member for just 159 rupees a month. Hope to see lots of you in our community.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.